You think the money you saved will simply land in your children's hands when you are gone? You think taxes were already paid? You think retirement accounts are a gift, not a trap. That belief is exactly where millions of American families are getting crushed right now. Baby boomers today control roughly $78 trillion more wealth than any generation before them, and about 30 trillion of that sits inside retirement accounts like IRAs and employer plans. That money is not neutral. It is loaded with tax consequences that activate the moment you die. And unless you understand the new rules, your kids will lose a massive portion of it. Stay with me because this is not theory. This is law. My name is Judith Carver. My role is to expose what most families are never told until it is too late. And hear this clearly. Your rights do not expire with age. Let us start with the hard truth. America is in the middle of the largest wealth transfer in history, and it is already in motion whether families are ready or not. Estimates show that baby boomers control roughly $78 trillion in total wealth, and nearly 30 trillion of that sits inside tax-deferred retirement accounts like traditional IRAs and employer-sponsored plans. That concentration alone should raise alarms because those dollars have never been fully taxed. They are promises waiting to be collected. Here is where everything shifted. The United States Congress passed the Secure Act, and with one stroke of legislation, it quietly ended the stretch IRA for most families. Before this change, an adult child inheriting a retirement account could spread withdrawals over their lifetime. A 45-year-old heir might stretch distributions over decades, keeping annual income low and tax brackets manageable. That strategy protected family wealth. That strategy is gone. Now, most non-spouse beneficiaries must fully empty inherited IRAs and employer plans within 10 years. That is not 10 years to start. That is 10 years total. The clock starts the year after death, and it does not pause for grief, job loss, illness, or confusion. This is not a planning preference. It is a legal requirement enforced by the Internal Revenue Service. Miss it, and penalties apply. Here is the real damage. The people inheriting these accounts are often earning peak income already. Adding forced withdrawals can push them into higher marginal tax brackets quickly. What looked like a gift becomes a tax accelerator. In some families, more than a third of the inherited account disappears to federal and state income taxes alone. That loss compounds when required minimum distributions continue during the 10-year window if the original owner had already reached distribution age. This is not about bad luck. It is about rules changing while most people were not watching. Families who do nothing will feel blindsided. Families who understand this early can still shape outcomes. That difference is everything. Here is where it gets ugly. The people inheriting these accounts are usually in their 40s, 50s, and early 60s. Peak earning years, high salaries, business income, required withdrawals from inherited accounts stack on top of that income and push them into higher tax brackets. The Internal Revenue Service taxes those withdrawals as ordinary income, not capital gains, not inheritance exclusions, ordinary income. That means a large portion of what you saved flows straight to the federal government. Now listen carefully because spouses are different. A surviving spouse has options no one else gets. They can perform what is called a spousal rollover. That allows them to move a deceased spouse's IRA into their own IRA. Once that happens, the account is no longer inherited. Required minimum distributions are based on the surviving spouse's age, not the deceased. The 10-year rule disappears. This flexibility is powerful but dangerous if misunderstood. Here is the catch most people miss. If the surviving spouse is younger and needs access to the money before reaching the penalty-free age, a spousal rollover can trigger early withdrawal penalties. In that case, treating the account as an inherited IRA temporarily may allow penalty-free access, but then the 10-year clock starts. One decision changes everything. Now let us talk about everyone else. Adult children, grandchildren, siblings, nieces, nephews, friends. These are non-spouse beneficiaries, and the rules are brutal. They cannot roll inherited IRAs into their own accounts. They cannot convert traditional inherited IRAs into Roth IRAs. That door is closed by law. The only flexibility they have is timing withdrawals within the 10-year window, and that window closes fast. This is where Roth accounts matter. If your child inherits a Roth IRA, the 10-year rule still applies, but the growth inside that window can be tax-free. That is massive. 10 years of compounding without taxes can double the account depending on market performance. That is not luck. That is a strategy executed during your lifetime. Now, here is where families get destroyed by details. Required minimum distributions may still apply during that 10-year window. Whether annual withdrawals are required depends on the age of the original account holder at death. If the original owner had already reached the required distribution age, then annual withdrawals must continue even after death, and the account must still be fully emptied by the end of the 10th year. Miss one required withdrawal, and the Internal Revenue Service can impose an excise tax penalty of 25% on the amount that should have been withdrawn, on top of income taxes. That is catastrophic. Pause for a moment because this gets worse. Improper rollovers trigger immediate taxation. With regular IRAs, you may have heard of 60-day rollovers. That option does not exist for inherited IRAs. Attempt it, and the entire account becomes taxable in 1 year. I have seen families accidentally create six-figure tax bills because someone assumed the rules were the same. They are not. Watch out for this because it ruins estates. Beneficiary designations override wills. Courts do not fix outdated paperwork. If an ex-spouse is listed, they inherit the account. If a deceased beneficiary remains listed, chaos follows. Taxes still apply, delays compound, emotions explode. Now here's the checklist that keeps people watching until the end because it decides whether your family wins or loses. Read it slowly and treat it like a control panel because each item prevents a specific failure that costs real money. 1. Confirm every retirement account has a living and up-to-date beneficiary listed. This includes old employer plans, small rollover accounts, and accounts you no longer actively monitor. Beneficiary forms override wills and trusts, and courts almost never intervene. One outdated name can redirect hundreds of thousands of dollars and trigger unnecessary taxes and legal fights. 2. Confirm whether each account is traditional or Roth. This distinction controls how much of your children's inheritance will be lost to income taxes. Traditional accounts carry deferred taxes that transfer to heirs, while Roth accounts can grow tax-free for a limited period if handled correctly. 3. Confirm whether Roth conversions during your lifetime could strategically lower your children's future tax burden. This is not about eliminating taxes, but shifting when and who pays them. Conversions done gradually can reduce forced withdrawals later. 4. Confirm your spouse understands spousal rollover options and timing. One rushed decision after a death can lock in penalties or remove access to needed income. 5. Confirm your children know the 10-year rule exists and understand the consequences of waiting too long or withdrawing too fast. Ignorance triggers penalties. 6. Confirm whether required minimum distributions have already begun, because that single fact determines ongoing obligations after death. 7. Confirm no one assumes 60-day rollovers apply to inherited accounts. That assumption alone can trigger a massive tax event. 8. Confirm beneficiary percentages align across accounts, so distributions do not create conflict or delays. 9. Confirm state tax rules have been reviewed because federal rules are not the whole picture. Then confirm a licensed attorney or qualified professional has reviewed your plan since the Secure Act changes This checklist is not paperwork, it is protection. This is the shift I want you to make. Stop thinking of retirement accounts as savings and start thinking of them as tax-sensitive instruments that demand planning. You worked too hard to let silence erase your intentions. If a situation ever feels legally or financially complex, contact a licensed attorney or qualified professional who can give you advice specific to your circumstances. You deserve calm clarity and respect. And if this information helps you recognize a pattern or avoid a costly mistake, share it with your friends, neighbors, or family members who may face the same risks. Many families lose money simply because no one warned them. Carry this forward with you. Your rights do not expire with age.